All right, welcome once again. This is the Employment Law Show. John Scholes here. Beside me, Lior Samfiru, co-founding partner, Samfiru Tumarkin LLP, the most positively reviewed law firm in this country. How about that? Reaching out anytime. We'll have this up on the screen throughout the next 30 minutes. But 1-855-821-5900, help@employmentlawyer.ca. And the website for you to use anytime, absolutely free and anonymous, pocketemploymentlawyer.ca. Lior will refer to that several times during the half hour, so buckle in. We got a lot to get through, including the 5 best times to contact an employment lawyer. That is on the way in just a bit. First, Lior, we always start with you and the week that was, something you've been working on. How are you?
Hey, John, I am great. Excited as always to be here to talk about employment law, to try to help some individuals solve some workplace problems, and of course, just inform people about what they need to know about workplace rights. There are so many misconceptions and half-truths when it comes to employment law, and that bothers me. And the reason why we started doing radio and TV many years ago is because, frankly, I got fed up with people believing misinformation about employment law and ended up walking away from legal rights that they have. Well, if you're watching this show right now, if you listen to any of our radio shows, you're going to be well informed about employment law. You're going to know what to do if you have a workplace problem. You're going to know how to respond if your boss makes a demand or gives you an ultimatum or lets you go. You're going to know what to do, what the law says, and what you are owed. That is exactly why we are here. Now, we cover a lot of topics on this show, on every show, but if we don't cover your specific issue or question, or if you actually want help resolving your workplace issue, not a problem. You can reach out to me and my team off air so we can get to work to help you. We'll give you that contact information throughout the show so that you can phone, you can email, you can send a text, whatever you want, so that we can connect and get that problem solved. But now that we know why we're here, let's get to it. Let me tell you about a situation that came across my desk just over the past number of days. I spoke with a lady who, like many others, was facing a vaccine mandate by her employer. And her employer made it clear that if she did not get the vaccine, then she'll be put on an unpaid leave. Well, this individual spoke to her doctor, and I'm not sure exactly the nature of that conversation, but the doctor ultimately concluded that for medical reasons, she should not be getting the COVID-19 vaccine. He gave her a doctor's note, and the doctor's note made it very clear that my patient, this individual, this employee cannot and should not get the vaccine. She gave that to her employer. Her employer absolutely was unhappy about it. That doesn't give us enough information. We don't know why. We need to understand the reason. You need to go back to your doctor. We want a detailed explanation as to why. And if you don't give us that, if you don't give us a detailed explanation as to why your doctor is saying you can't get the vaccine, then we're going to disregard it completely. We're going to put you on an unpaid leave. Too bad. Well, that's when she contacted me, and her question to me really was simple. Do I have to give more information? Or is it enough that my doctor says I should not get the vaccine? So here's the answer. The answer is very clear and very simple. All that she needs, all that anyone needs, is a doctor's note saying, with respect to a vaccine, that you can't get it. Your employer doesn't have the right to know why. Your employer doesn't have a right to know what made your doctor conclude that. They don't have the ability to question your doctor's medical opinion. All you need is a doctor's note saying that you can't get it. And in that case, your employer has to find a way to accommodate you. So it's improper for the employer to ask for this information. And by the way, this doesn't just extend to vaccine issues. If you have a doctor's note saying you can't work, or you need accommodation, or you can't stand for more than 2 hours, that's all you need. Your employer doesn't have the ability and the right to question that and say, well, no, we need to know why. We need to know what medication you're taking, what treatment you're taking. That is private information. All you need to be able to tell your employer is, can you work, or what accommodation you need, or can you get the vaccine for medical reasons? So in this case, that employer, arguably by not accommodating, that's a human rights violation. It can be a constructive dismissal. So an important reminder how powerful a doctor's note is, and you do not need to provide specifics as to your medical condition.
Does it change if this person, say, for instance, they didn't need or not take the vaccine for medical reasons? Maybe the workplace doesn't have a vaccine mandate. It's not a federal place. It's just a private company. They just choose not to get the vaccine. They have all along. Then what is the employer's stance at that point?
Well, you're right. And this is probably the biggest issue that I've been dealing with over the past 6 months or so. And that is individuals that have chosen for their reasons not to get the vaccine, and then they either lose their job or they're placed on an unpaid leave. So here's the answer to that. If you lose your job, you are owed severance. If you're placed on an unpaid leave, you can treat that as a termination and, again, get severance. That could be as much as 2 years pay, 24 months. So your employer does not have the ability to just suspend your employment or to let you go without compensation. Now, they can let you go, but they have to pay you. And a lot of employers don't appreciate that. They're letting people go thinking that they can do that because the employee chose not to be vaccinated. But no, severance has to be paid. We're right now, John, representing hundreds of people across Canada that have chosen not to get the vaccine, and they were let go without compensation. Our job is to get them the compensation that they're owed.
And again, anytime, pocketemploymentlawyer.ca, as Lior mentioned, get that right compensation. Inside that is the severance pay calculator, which, by the way, has been used and viewed by over 2 million people now, which is an unbelievable number, but it's true. Again, pocketemploymentlawyer.ca to use that severance pay calculator, which we're going to refer to here in just a bit, guaranteed. But employmentlawyer.ca, that website is the firm website. Go there anytime. There's a media tab. From that, you can search out a station that carries our radio show. As Lior mentioned, it's been many years, working on a decade, I guess, on the air. Hour-long shows, ton of phone calls every week. We play them back here and we talk about them, Lior. So the first call from the radio show is coming up now.
Salaried employee. I've been full-time for just over 4 years. It looks like the company has come on some hard times, and I'm fairly certain they're going to be closing the doors. I'm just wondering what I should expect for severance and unused vacation, etc.
Number one, how old are you and what kind of a job do you do?
41 years old. I'm in management.
Wow.
So, John, this is a common scenario, unfortunately, especially these days. A lot of companies, because of the pandemic, have struggled. They have had to restructure, to make cuts, to let people go, not because the individuals did something wrong, but because the business realities that they're facing. Now, they can do that, but the fact that an employer is struggling financially does not relieve them of their severance obligations. They don't get to pay less severance just because they have to make changes because of the pandemic. The same severance has to be paid whether the business is doing amazingly well or if it's struggling financially. So the question, the big question is for this individual. He's concerned about losing his job again because of the pandemic and the effects of the pandemic on the business. The question is how much severance he is owed. So you mentioned it before, and I'm going to use it right now. Our severance calculator. You can find it at pocketemploymentlawyer.ca. Let's take that information, let's plug it in, and let's see how much severance this person is owed. He's 41 years old. He's in management. He's been there for 4 years. And right now, we don't know anything about severance, except we know, you see that at the bottom, that he is owed somewhere between 8 to 9 months of pay, 8 to 9 months of severance. 4 years of employment, he's going to get 8 to 9 months pay. And that's even though, John, that employer may be struggling or may be facing financial difficulties because of the pandemic. Same with you. If you're losing your job, worried about losing your job, if you're just curious and want to know how much you're owed, you can find out right now in seconds how much severance you are legally entitled to. All you have to do is you go to pocketemploymentlawyer.ca and use our severance calculator tool. You'll be glad you did.
Now, if, Lior, you put on your employer hat for a moment. An employer, as you said, many are struggling financially. They may not be able to afford that much severance, even though it's the proper thing and they're legally bound to do that. Is there another option for them? Can you do, anything else to alleviate the financial strain on these employers? Working notice, maybe?
Yeah, the reality is that if an employer, short of a bankruptcy, they have to comply with the law. And that may mean putting yourself in a more difficult financial situation. That's why we have laws. Now, an employer that had some foresight perhaps would have used an employment agreement that limited future severance. An employer can do that. But if the employer has not done that, if they have not properly limited severance by way of an employment agreement, they have to pay the full amount. Even as you've said, they may be struggling financially.
Want to move on to terminationquestions.com, and another website, again, free and easy for you to use, terminationquestions.com. It's exactly that. You send in your questions. They might get on air here in the show. Otherwise, Lior's team does answer them quite regularly. This one comes from Amy. Right now, Lior says, a large company I work for informed our team last week that they would be restructuring and many of our jobs would be changing. My schedule will now include weekend shifts and new responsibilities that I never asked for. Do I have to accept these changes?
So another common effect, John, of the pandemic has not just been people losing their job, but jobs changing, hours changing, shifts changing, responsibilities changing. And every single time we look or consider changes to the job, the term constructive dismissal should come to mind. So here's what that means. It means that your employer does not have the right to make significant changes to the terms of employment. Yes, they can make some changes. They can change your hours. Instead of 9 to 5, they can make it 8:30 to 4:30. Instead of operating machine 1, you may have to operate machine 2. But what they can't do is they can't demote you. They can't give you significantly different jobs. They can't give you different shifts, different hours, or perhaps make you work weekends when you're not working weekends otherwise. All those are significant changes. And if your employer implements that, you can choose, if you want, to treat that change as a termination, again, constructive dismissal, and get your severance. So you may not be able to physically stop your employer from making changes, but what you can do is choose to treat that as a termination, not to accept that, and get severance. So for Amy, that is the option that she has here. If she's not content to continue working with these changes, constructive dismissal is a real option, and she should give me a call right away.
For those who are kind of in this situation, kind of stuck between a rock and a hard place, they don't want these changes to take place, or maybe they don't really like it, but at the same time, they love their job. They like their co-workers and their colleagues. Can they maybe try some of these changes out to see if they'll work? I mean, if you're a single guy and they're going from days to nights, that might be good for you. It might not be, but can you at least try it and not commit to it long term?
You can. You would have a small window to try these changes, but what I want you to do in that situation, I want you to tell your employer in writing that that is what you're doing. So I would tell your employer, you've changed my job, you've changed my shift. I'm not happy about that. I am willing to try it and see how it goes. So I'm going to try it over the next few weeks, and then I'm going to let you know how I feel about it. As long as you do that and for a few weeks and you put that in writing, that's okay. If you don't say anything, but you just continue working, you're going to be considered to have accepted the change, and then you can't do much. So always, always put it in writing.
All right, we'll take a short break now. Get right back to it. 5 times, the 5 best times to reach out to an employment lawyer are on the way. The number in the meantime, 1-855-821-5900, help@employmentlawyer.ca. We continue with the Employment Law Show. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Employment Law Show again. John Scholes beside me, Lior Samfiru, always every week educating you about your employment rights. There's tons out there that are really, really good for you, but you got to know what they are and you got to be able to exercise them as well. Good way to educate yourself every week is listen and watch this show. 30 minutes of great knowledge. Radio show can be found. EmploymentLawyer.ca is the website in the media tab. But Lior, I want to get to this, our topic for the day, and it really is the 5 best times to contact an employment lawyer. I'd even call it 5 necessary times, the most necessary times to contact someone like yourself, an employment lawyer. Number 1 is this: if the fundamental terms of your job have changed, pay, schedule, location. We just touched on this before the break, but it goes wider than that, doesn't it?
Probably one of the times that not only do you have to contact an employment lawyer, you have to contact an employment lawyer quickly, is when the terms of your employment are being changed in a significant way. And that's a very common occurrence. Your compensation is reduced, your hours are changed, your shifts, maybe you've been demoted, maybe there's a relocation, they've moved offices and spaces. Well, you have to contact an employment lawyer. You have to contact me as soon as possible. And here's why. First of all, constructive dismissal, right? To pursue a constructive dismissal in that situation, you need to have a chat with me. You need to get legal help. You're not going to be able to do that on your own. But it goes beyond that. If you accept the change or continue working, not only are you then stuck with that change, okay? Let's say you continued working despite a pay cut. Well, you've accepted it, now you're making less money, but it's worse than that. If you've accepted it, you've given the company the right to do it again. So maybe they reduced your pay, you accepted, you continued working. Well, by doing that, now they can do it again. And the second time they do it, you won't be able to do anything about it. The third time, the fourth time, the fifth time. Nothing can be done because you let it happen. That's why it's important. Anytime we're looking at changes to terms of employment, you don't look away and ignore it and hope for the best, okay? You gotta give me a call. Oftentimes we can remind the employer of their obligations and maybe change their mind and have them back off that change. Or if we need to, we can pursue a constructive dismissal. If you're facing a change to the terms of employment, don't sit on that, don't wait. Time is not on your side, okay? Give me a call right away, and let's talk about all the options.
And I think this even goes as far as that point is concerned, even if it's just, maybe the whole department are suffering these changes as well, but those things can often affect two different people very differently. You and I may work for the same company. You know, you drive to work, I got to take a bus, so they move the company 10 kilometers away. Now I've got 3 buses, but for you, it's like, it's it's no big deal. So it's very individual, but at the same time, everybody should be reaching out, right?
Well, the thing is, a lot of employers think, or employees think that, well, if the change applies to everyone, if they're doing the same thing to everyone, it must be right. That clearly, I can't do anything about it because everyone is affected the same way. Not at all. The fact that everyone is being put in the same position does not make it legal. Okay, everyone could be constructively dismissed, or your situation may be different. Either way, whether it's your terms of employment that are being changed, or everyone in the workplace's terms are being changed. Either way, you have rights, and it starts by making that phone call and getting some advice.
Number 2 thing you got to do, reach out to Lior when this happens to you, and you love this one, when you are given a new employment contract, because we all love something new and shiny, don't we?
Yeah, you know what? And this is where I always get on my soapbox and talk about how bad and how problematic new employment agreements are. And I'm going to make this very simple, as I usually do. If you're working, you have a job, and all of a sudden your employer says, I need you to sign a new employment agreement, it's always bad news. It's never a good thing, okay? It's never going to be a situation where you're better off having signed that agreement than not having signed it. The reason the employer would want you to all of a sudden sign a new employment agreement is because those terms are better for the employer. For example, there could be a term in there, likely is, that limits your future severance. So you sign that employment agreement, 6 months later they let you go, you could have lost $100,000 in severance because you signed that agreement 6 months prior. Or it could be terms that allow the company to change your job, that allow the company to lay you off temporarily. All of those things that they don't have a right to do unless you sign an employment agreement giving them that power. So no, anytime you're faced with an employment agreement like that, be concerned. Call me. Right away, let's review it together. Let me tell you what it means, what it does, and what you can do in terms of not signing. You cannot be made to sign it, and in many cases, you are far better off returning it just as nicely as your employer gave it to you and say, thanks, but no thanks.
A lot of people are going to be scared to do that, thinking, well, if I return it and say no, they're going to say, well, then out the door you go.
And they might. I mean, not likely, but they might. And if they do that, though, they pay you full severance. I think that's much better than that you get severance now, as opposed to signing this and then losing your job and getting 8 weeks pay instead of 2 years pay. So you tell me if you think that makes sense. I would rather you get your severance right now, move on to another job, than face financial ruin potentially later on.
We're going through the 5 best times to reach out when you must contact an employment lawyer. Number 3 is this, Lior: complaints of harassment or bullying have not been investigated or dealt with.
So the default action, if you're facing bullying, harassment, a poison work environment, is to try to deal with it internally. To tell someone, to talk to someone, HR, the owner, whoever the right person is in your workplace, and let them know what happens. And you do that because your employer is under a legal obligation to investigate and then to rectify the problem, to fix the issue, okay? So very important to try to do that internally. But if you've done that and nothing has happened, either your employer did not take it seriously or they just didn't work hard to resolve the issue, then you call me and we deal with it externally. Okay? That might mean that I can give the employer a kick in the rear end so that they can do what they're supposed to do, or it means that I get you out of there with compensation. Because the law says if you haven't been properly treated and your employer has not fixed that problem, that's a constructive dismissal. Potentially, it could also be a human rights violation. So whenever you've exhausted the internal options, you call me, we deal with it externally. The law does provide some very good remedies for individuals facing workplace harassment.
And you always know the follow-up question when we talk about this. What happens if the person you're supposed to report to, i.e. the boss, is the one doing the harassing or bullying?
Well, obviously, if you can't deal with it internally, there's no one to talk to. Who am I going to talk to? The owner of the company is harassing me. What am I going to do? Talk to his underling? Obviously, that doesn't make sense. So that means you're going to contact me even sooner. That means that if you're not able to deal with it internally, that's not an option. There's no mechanism for you to fix that problem. Then that's when I get involved even earlier than that. So that's when you don't wait. You don't sit on your rights. You call me right away.
All right, number 4 in the best reasons, best times to call Lior. This one has been huge over the last 2 years, and that is when you're put on a temporary layoff without your consent.
So many people over the past 2 years during this pandemic have been put on a temporary layoff. Depending on where you are, some employers may have said, no, it's not even a temporary layoff. It's an infectious disease emergency leave. Either way, it doesn't matter. If you've been put off work, you have the right to treat that as a termination. Whether it's an infectious disease leave or just a plain old temporary layoff, you don't have the obligation. You're not required to sit and wait. You can treat that as a termination. And for that, you call me. I've really been working with hundreds of people across Canada, maybe thousands of people, frankly, over the past 2 years that have been put on this layoff and gotten them their compensation. Because the alternative is you sit at home, fingers crossed, hoping for the best that your employer is going to call you back to work. And some people have been waiting for 2 years now. Enough is enough. Whether it's because of the pandemic or maybe it has nothing to do with the pandemic. If you're put on a temporary layoff, you don't have to wait a week, a month, 6 months, whatever it is. You can choose to treat it on day one if you want as a termination of your employment. Of course, John, we're talking about non-union employees only.
Yes.
But you can treat it as a termination, get your severance. For that, you call me, and you call me right away. It's actually a fairly simple process, John, to get it done.
5th and final reason why you should call Lior immediately. You've been given a severance package. You've been terminated. You got to sign it. It's right in front of you.
We saved the biggest one for last, John. That is the main reason. The number one time when you must call me. You must do that. You must contact me, because if you're looking at that severance letter, I can tell you just by virtue of experience, without having read a word of it, that whatever the company said they're going to pay you is a lot less, and I mean a lot, less than what you're owed. Okay? In 90% of cases, that severance offer, the amount offered, the amount that the company says we're going to pay you, is not even close to being in line with what the law says you should have. So it's not a week per year. It's not 2 weeks per year. For the vast majority of people, it's a lot more than that. You could be owed 2 years' pay. You could have worked for a few months and could be owed a few months of severance. So please make the right call. If you sign that offer and the next day you realize you're owed another $50,000, which you probably are, then guess what? You can't go back. You can't say, oh, I didn't know. You can't say I felt the pressure. You can't say that, my financial concerns made me do it. If you sign it, you're stuck with it. So you call me anytime and every time you're looking at a severance letter.
Going to grab another phone call from a radio show, but first we will take a short break. Before we get into that, how do you contact Lior? As we mentioned, you always should. 1-855-821-5900 and help@employmentlawyer.ca. That is coming right up. So we'll get to a phone call right now. What do you say?
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. Employmentlawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at employmentlawyer.ca.
All right, welcome back, Employment Law Show. I want to go back to back with a couple of phone calls. Again, our radio show, easily found, employmentlawyer.ca, the media tab, and there you go. There's somewhere across the country where you can catch Lior and I and the rest of his team doing hour-long programs. They're fantastic. So we'll get to a second phone call for the day right now, Lior.
I was let go recently from my job. It was within the probationary period. I had COVID. I was at home. I was obviously isolating probably about 3 weeks. I was at home. I was told that you're not supposed to go back to work unless your symptoms are all gone. They let me go within the probationary period. They have to pay me some kind of severance or separation pay. Am I entitled to that?
I know our company's coming up to time of year where they're looking to cut back, and being at the age that I am in 60 and in a big telecommunication company as a network specialist, I make about $100,000 a year with at least a 20% bonus every year. Now, I guess the question I have is, should it always be with the bonus added? Because they always say, well, it's a variable, but I've never dropped between 15 and 20. And then should it be closer to 2 years, being I'm 60, for example, so 22 years?
Two very different phone calls. Tackle the first one first, Bill.
So the first one raises this issue of being on probation, and that's an important topic because there's an assumption. We started the show by talking about people believing half-truth or misconceptions. One of these misconceptions is that, well, if I'm in the first 3 months, if I'm on probation, I don't get severance. That's not true necessarily at all. You're only on probation, and you only don't get severance if you sign an employment agreement that specifically says, number one, you're on probation, and number two, you don't get severance. It's not automatic. Probation doesn't exist unless you sign an agreement specifically saying you are on probation. And many employees, for them, that means if they're let go on probation, yes, you're owed severance. And believe me, John, even if you worked for 2 months, you could be owed 2 months, 3 months, 4 months of severance. And if he's let go because of COVID symptoms, that can also be a human rights violation. So there's a lot to discuss here. So if you're let go on day one of the job or day 2001, we need to speak right away. And going to that second call. So that second call asked a very simple question is, after 22 years of employment, someone that's 60 years old, how much severance is he going to be owed? Now, we know that that's going to be a significant amount, and he was told he's not going to get a lot of severance, but I'm saying he's going to be owed a significant amount. So this is where we're going to go back to pocketemploymentlawyer.ca. Let's plug the information into our severance calculator and see exactly what this person is owed after his 22 years of service. So, John, we know that this person is a telecommunications specialist, 60 years old, been there for 22 years. Severance for him is as much as 22 months, somewhere between 18 to 22 months. So obviously that's going to be a significant amount of money. And I'm showing this to you to show you how simple it is to use our severance calculator at pocketemploymentlawyer.ca. Do that now, even if you haven't lost your job. You never know when you'll need to have that information handy.
Yeah, that's a lot of it, especially the assumption is, I'm not going to be owed very much. Imagine the money left on the table if this person didn't go through this exercise. So again, to your point, Lior, always use a severance pay calculator. When in doubt, pocketemploymentlawyer.ca is where you want to go. Reach out for the phone number now that we're done for another show, 1-855-821-5900. And that email address, you can reach out anytime to Lior as well, help@employmentlawyer.ca. We'll catch you next time, Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.